Any mention? Any mention? Item number 1.
I think you should stop all video virtual hearing. There's a way. Yes, no one appearing. There's no appearance of the parties list after 2 weeks.
2.
Too much. We can't even see you. Who is that? Last time no one appeared for respondent. Last time no one appeared for respondent. Where's the petitioner? What is this? I think we have to discontinue this virtual hearing with regard to these matters. This is matter for on after 2 weeks physical presence required of counsels.
Lordship, am I audible now, Lordship?
We have adjourned for 2 weeks. Please come physically.
Item number
Lordship, yes, Lordship, yes.
Had
Item
enough
number
of
2.
this advantages taken by the counsels.
Item
Yes.
number 2.
I see. Here also, where's the you are appearing here? Who appears for respondent?
Yes. On behalf of Sir Paul.
Huh?
On behalf of Sir Paul.
Number 2, item number 2. Efficient hotels. Who's for the petitioner? Same order to appear physically next date. Yes.
Hearing. Item number 3.
Archly see that. Are you somewhere else? The coordination of BDA. You have today.
My lord, here it is, this petition, Nokma Council was represented by its president who died. So we have filed an application for substitution, my lord. Another president has been.
President is that. Oh, sir. Oh. Yes, who's the appeal correspondent? Where's the application?
I'm there for the state, Your Lordship.
No, and for the other respondents?
This council is here.
He's correct. When is this new person is the president?
Yes, my lord.
Duly elected.
Yes.
This is Annexure B.
Yes.
That is Winnie's son, C.H. Marak.
Yes, my lord.
Yes. Due to demise of the earlier president of the Nokma, Council of Nokmas, who was presenting the, due to death of the, due to the demise of the President Secretary sitting here earlier on.
President and secretary both were representing the council.
Yes, then no, but the names were not given in
President has been
in your writ petition. See,
name is not. But affidavit name is there, my lord.
Then how will substitute? No name is given. See,
Name is not there,
taken on
but
board also, yes.
but in affidavit his name appears.
Ah, well and good. But then, the examiner of course tried to see whether.
Okay.
This case number 26 of 2026 in law 0492. This is an application for substitution of the president of the Council of Nokma, Garo Hills, by the instant applicant due to demise of the earlier president who had sworn the affidavit in his capacity as president. So, no objection.
No,
Still
Lordship.
objected to by the counsel for respondents. Accordingly, the misapplications allowed. So, you don't need to make any corrections in the court.
No.
Are you ready with the matter today?
No, my lord. No. Let it after 2 weeks, Mr.
After corrected data also there. Subject to lordship convenience, I pray for only this thing for 5 million.
We will do it today if you are ready.
The senior counsel fix for.
No, I'm not ready. Sorry.
Yes, just after
2 weeks.
2 weeks.
2 weeks for hearing. Yes.
Oblige, Lordship.
Item number 5. Item number 5.
Well, Lord, I have submitted my submission earlier occasion, and Lordship directed the respondent counsel and the state respondent to advance their submission, my Lord.
Where's the who's appearing for district council?
My esteemed colleague, Mr. Kastapal, is appearing for district council, and Learned AG is for the state.
Who's there? Where's that boy who appeared just now on behalf of Mr. Paul? Yes,
Lord, in-
he's coming now.
Lordship is
On his
on.
way.
Lordship.
Yes. With any other matter, Karan? Does last matter? Is he on his way?
Lordship will take some time. Lordship may have it next week, Lordship.
This is the rendered redundant. Yes, when the matter is called out, the counsel are present. Such this up to 1 week.
Obliged, Lordship.
That's it.
Any mention?
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 30 on behalf of Mr. J. Shilla, Your Lordship. For respondent number 6, Your Lordship.
What's the matter about? Yes. Ahmed Idhar.
Regarding the checkpoint.
Regarding appointment?
Checkpoint.
Checkpoint?
Yes.
You have no objection? To adjournment?
Then it come after 1 week, Lordship.
You have no objection?
No objection.
Okay, yes.
Obliged, Your Lordship.
My Lord, I also beg to mention item 46, my Lord. This is
46?
a 46, my Lord. Item 46. I am the petitioner, my Lord. This is a Nehu matter.
Yes, who's other side?
I have no objection, Lordship.
Will come after a week, my Lord.
Yes.
Obliged.
Wait, please, Lordship. Lordship, I beg to mention item number 44.
Other side?
No objection, Lordship.
I'm praying for 2 weeks, Lordship.
Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 31, Your Lordship.
Lordship, nothing left in this matter, Lordship.
Your Lordship, it's about
Demarcation, Your Lordship.
VC?
Demarcation, Your Lordship. Lordship,
Oh yes, where's Mr. Zarika?
He
So
is
tell him to
not-
come, we'll take up the matter.
he
This
is
is the
ha-
time did not appear for demarcation, correct?
he's having some health issues, Your Lordship.
You're there, you have briefs with you.
I don't have the brief.
This is not done at all.
2 weeks
Have
time,
it
Your
there for
Lordship.
tomorrow. Or day after. Oh, it's Friday, sorry. Like Monday.
1 week, Your Lordship.
1 week is a fixed matter. They've taken enough adjournment. I remember this matter now. You come for demarcation and then you don't attend the demarcation yourself. Yes.
Obliged.
Monday is a fixed matter.
Please, Your Lordship. Lordship,
Yes.
I beg to mention item number 40 to 43. They're all connected matters. The conducting counsel
Why?
is having some personal difficulty to conduct the case today.
40 to 43?
Lordship. They are similar
You
matters.
have a brief with you. Argue it.
On the next
What's the
day,
matter
Your Lordship.
about?
These are the recognition.
For challenging the advertisement for some post in the
Which post
health
is this?
department.
What personal difficulties does he have?
These are all grade
ill.
4. Lordship. He's here, but he's arguing some other matter, Your Lordship. Have it
That
on
is
another
matter.
date.
I have no objections.
We have no objection, but yes, after 2 weeks.
TV image.
TV obliged, Your Lordship.
My Lord, 32 to 37 and 39 is also connected with
No, the Mr. Nath matter.
Yes, my Lord. It is a connected matter, my Lord. With 40
Where's
to
Mr.
43.
Nath?
It's out of station.
Yes.
Yes, my Lord. My Lord, no objection.
What's there in the matter? They are all temporary appointees, correct?
Yes, my Lord.
Then?
Nothing left, Lordship. Actually, Lordship, right now, recruitment has almost completed, but then due to elections.
What elections?
Lordship, this council elections.
We'll fix it next week. It's a fixed matter, okay? All these matters.
Yes,
32 to
32 to 37 and
37
39.
and
39.
40 to 43. Right?
39 to 44, Lordship.
Yes, huh?
39 to
43.
43.
Next week is a fixed matter. Yes. We won't keep them unnecessarily pending. Yes.
Highly obliged, my Lord.
Yes.
May I please, Your Lordship? I beg to mention item 47, Your Lordship. I pray for 1 week time, Your Lordship, for hearing. I'm appearing on behalf of Ankara.
Who's the other side? S. Lalu.
Hello. No objection.
Okay, yes. Yes.
Reading item number 45, my lord. The conducting counsel has some health issue, my lord. Kindly
Mr. Pathak.
examine it. Mr. V. Kumar, my lord.
After 2 weeks, yes. They don't take adjournments. Pathak now. Yes. Yes.
This matter is hard. They're supposed to come with successful.
Right.
1 week or 2.
Yes.
Supplementary list item number 1.
My lord, in this matter, on the day before yesterday, my lord I've taken it time to seek instructions, my lord, as to whether the challans were there at the time of the seizure, my lord. It was there, my lord. It was there. It was there with them, with the driver and also with the handyman, my lord. But they never insisted. They never insisted on the challans, my lord. And also, my lord, in the evening.
You need to insist if they intercept you.
Yes.
To say that you're carrying contraband. It is common sense that you say like these are my papers. Suppose you're driving without license, say Mr. Yubin, you're driving without license, put you in jail, and you won't show your license.
No, my lord, exactly that. Can you look at page 16, my lord, just to substantiate what I'm saying also, my lord. Page 16, my lord. Page 16, my lord. The first is a description of goods, my lord, 160, quantity, my lord, estimated value, the remarks. Can you look at the remarks, my lord? Driver and helper of the seized vehicle have stated that they loaded a dried Arakana nut from the Indo-Bangla border at Wakadai, East Janti Hills District, Meghalaya, and meant to reach Shalang, West Khasi Hills District, my lord. Now the column, my lord, below. Tata 06 wheeler truck bearing so and so. Now, next remarks, my lord, no vehicular documents found with the driver and the helper. The exact value will be ascertained as per DTO Meghalaya. Now, if, my lord, if even the challans were not there, my lord, they could have remarks here, my lord. And now, my lord, what they're saying is, my lord, can you look at the Caesar place, my lord? The Soyong. The Caesar place is the Soyong, my lord. Yeah. Now, my lord, they're saying that we have transported all the way from all the way from Wakadai, Dauki, my lord. This is what the custom was saying.
Not saying this is what they have said. Your driver and
no, these drivers are, my lord, there was a lot of communication because this driver does not understand Hindi, doesn't understand English, my lord. They were never made to explain.
He didn't know where to go also. He didn't know where it's coming from.
There's a local, no. They are local boys, my lord. They would definitely know, my lord, how to transport
know
them.
Where they loaded it from. And Soyong is on the way to Shalang because this is the new highway at Gusudongstoin.
My lord, now, my lord, even if, my lord, assuming for a moment what they are saying is correct, my lord. In Peninsula, my lord, there is a custom gate, my lord. In Peninsula, because I cannot bypass Peninsula, my lord. There's a custom gate. If I was really transporting from Wakadai, then I have to come to all the way Soyong to reach Soyong. I have to pass Peninsula. Then it is their own officers mending there.
Submission is source information. Now you will not stop. If you're carrying this patah, why should you stop at a customs gate? Peninsula customs gate for. We will not go there.
My lord,
but the thing is that, whatever it is, the remark that is, you have admitted the driver that they loaded at Wakaraj, which is in the border, right?
My lord.
That's it.
My lord.
What do you want? You want release of the...
My lord, but I'm saying we want portion of the seizure. Can you see the prayer,
why, my lord, kindly look at this, my lord.
My lord, investigation is just been initiated, my lord. He should cooperate with the investigation.
What's NCV?
Net commercial value.
My lord, illegal importation, my lord. There has to be a reason to suspect, my lord. What is my lord? Can you look at the I'll just place one case, my lord, of the Assam Super East Traders case, my lord. Can you have a look at this one? Under what circumstances only they can seize my page paragraph 23 of this petition, my lord. Sir, just give a search also one.
High Court, this is Patna.
My lord, this is passed by a division bench, my lord. Just for a referential value, my lord. Paragraph 23, may I permitted to read, my lord? In the, my lord has got?
Yes.
In the present case, core issues are as follows: whether is there any compliance to Section 110 of the Act 1962 to the extent of not assigning the reasons in support of reason to belief or not. Whether local traders' opinion on the seized dried Aracana nuts to the extent of foreign origin could be reliable and acceptable or not. Whether opinion
you talk about reason to believe, that means
yes,
there was no reasons given.
Yes, there was no reason, my lord. Kindly look at the seizure, my lord. They just said it's an importation, and now they say the source information.
Instructions.
My lord, in the meantime, my lord, no coercive action should be taken against me, my lord. My lord, they are summoning. I'm a lady, my lord, all the way. Sick lady.
You have to cooperate with investigating authority.
My lord, I am ready to cooperate in the investigation, my lord. But Section 123 against.
You should make out a case.
My lord,
that is
my lord,
total,
because
there's been a total what do you call it?
No, because my lord, under Section 123, my lord, the burden of proof doesn't lies on me, my lord. It lies on the customer, my lord. Now they're saying there's an importation. Now they have nothing to say. Now saying that they source information, my lord. And they
heard Mr. P. Yogin, who submits that on instructions received, the documents showing the origin of the supari was in the possession of the drivers, was in the possession of the driver of the vehicle, but however was not produced at the time of seizure. Stop. Further submits that the only reason given is seizure memo is that the only reason is given in memo is of illegal importation. It does not amount to a reason that will warrant such action by the custom authorities. Dr. N. Mozica appearing for the respondents, yes, to obtain instructions to file affidavit, also provide details of status investigation just after 1 week. Yes.
But the petitioner should cooperate with the investigation also.
Yes, it is also expected that the petitioner cooperate with investigation. We will take up the matter of your release next year. Let them come.
My lord. And my application under Section 110 is also pending. They have not done anything.
No, they will whatever they'll do in a conflict law. Let them investigate 110. But if they feel that they'll release the goods to you, that's up to them.
If it's demand, my lord, I reserve my right to file damage.
Of course, your right cannot be extinguished.
My lord. Obliged, Lordship.
Maybe please, Your Lordship.
Yes.
Yeah, what happened, Your Lordship, earlier competition about page 26, the alignment was circular way, then again they took another land.
No, what's the matter?
Land compensation.
Oh, land compensation.
Land compensation. So
I don't understand you saying.
Yes.
You shoot your
page,
hands.
No, page 26, Your Lordship, the diagram I have given.
Give this, not as fast as you, Mr. Manta. Yes,
So
page 26, yes.
That annexure 8, Your Lordship. The new alignment has been made for that they have not paid. That is also through the same mile.
1 second. Page 26.
Page 26.
Well, for which?
Yes.
Where is the location?
It is Bagmara. It is going to the Bagmara from Radhikar, Your Lordship.
Yes.
The old alignment they have paid, and the new alignment they have not paid me.
Old alignment meaning?
Old the round way.
Yes.
From the same land, then they made a dumping ground on my own land. For that also they have not paid anything. So that enquiry was caused.
Prayer here.
Praise to means the NHIDCL. They have issued a letter after getting the enquiry collected by the Deputy Commissioner at page 25A, Your Lordship. They have given a suggestion.
What impugn letter is it? Next 11.
Impugn letter, Your Lordship, is at page annexure 11, Your Lordship.
Yes. What is this? Complaint.
Page 34, Your Lordship.
Yes.
Dated 21/11.
Just can you read it? Huh?
Dated 21/11/25, page 34, Your Lordship. Issued by NHIDCL. Also, I am a complaint against access area cutting for construction of Surenso Road, Ranikar, Nonghala, Moheskula, Bagmara. They have stated that within the approved alignment, but
during the complaint
during the joint inspection conducted on 31/7, Surenso, in the presence of officials from the district administration, Surenso EPC contractor, it was clearly established that all construction activities were carried out strictly within the approved alignment and the right of way limits handed over to the NHI by the district administration. Furthermore, the authorities engineer, after detailed review and verification, has also confirmed that the art cutting works were executed entirely within the designated ROW right of way. This office has also examined the matter and found that all construction rights, including art cutting, have been taken in accordance with the approved alignment and acquired so-and-so right of way. So I am agreed by this because why? At page 25A, Your Lordship, the inquiry was caused by Deputy Commissioner.
When was it?
Inquiry was conducted by Deputy Commissioner, Your Lordship, and finding was given in a conclusion, page 25B. Page 25B.
This was done which date?
This was done prior to the impugnator, Your Lordship.
Prior to impugnator.
Prior to the impugnator. So, the conclusion, they say that NHIDCL may be directed to provide documentary proof of its claim to the complainant that a compensation was paid for the new alignment.
Then let them come. Yes, sir.
Let them come.
Senior counsel, assisted by so-and-so. MS Alconi is present.
1, 2, 3, madam.
Lenergy is present.
1 to 4, sorry.
1 to 4, 5, I think. Suman Sen is there. Mr.
Notice to issue to the respondent number 5 within 3 days, just after 2 weeks. Much. 3 days.
Deeply obvious.
Daily list item number 1.
Yes.
Wait, please, Lordship. They were supposed to file their objection in Lordship.
Yes.
I've only filed my objection.
Yes.
Only serve the copy as well.
Yes. Recorder, come. Yes, start.
Lordship.
Is your application? Yes.
Lordship, Senior Counsel Mr. Paul is on legs, Your Lordship.
On legs where?
In courtroom number 1, Your Lordship.
Well, we'll take after some time. Well, now. Yes. Next.
Item number 2.
Please, Lordship, this matter I have filed the affidavit of service indicating the respondent number 2 also have received the service report, Your Lordship. I have filed on the last occasion the respondent number 2 have received the
number 2.
Now number 2 is my lord is
Assistant Agriculture Engineer.
Yes, Lordship. This is the assistant engineer.
Yes. Services on the in giving service notice on number 2. Such service complete on both the respondents. Yes.
Your Lordship, I'm appearing on behalf of respondent number 1. We have filed our affidavit, Your Lordship.
What does affidavit say?
I have not gone through, Your Lordship, because
you have not gone through. Why? When is the affidavit filed? Let's see.
In December, Your Lordship.
December. Too busy. Yes, let's see affidavit. Number 1. Is there any willful violation?
No, Your Lordship. Your Lordship, steps had been taken. Had been duly taken by the respondent, Your Lordship, and however the delay was because they had to get approval, Your Lordship, from the government.
3 months from today. What is it? 9.
They have only forwarded a letter, but they have not fully complied.
For regularization matters of ad hoc employees, Your Lordship, the cabinet has to give approval, Your Lordship. The delay was because it had to be put up before the cabinet, Your Lordship. Your Lordship, moreover, the order that was passed by this Honorable Court was for consideration, Your Lordship, not to grant regularization.
Resolution may either reject or allow. That's consideration.
Yes, Your Lordship.
We're not saying appoint or regularize, but consideration means.
They should have filed an application for extension of this time.
What time extension?
To extend the
responsibility of arrears is beyond their scope. They are just at the directorate level. They have no power to regularize unless they get approval from the personnel department.
Moreover, Your Lordship, this respondent has since retired.
You see this letter 18 March 2025. Have you read this? You know, borrowed read affidavit also. Mr. Sangma. For contempt, we have to make out that they are acting in blatant violation of the court's order. And from the two respondents here, the both in the Agriculture Department, where is the willful violation? They have written again 18 March. See. Read. What does it read? See, read that letter. Read it.
With reference to subsection above, I am forwarding herewith a copy of the letter received from Under Secretary, Department of Agriculture and Farmer Welfare, Personal Administrative Reform. B department where staff under your office are in the list of ad hoc employees who are to be regularized. You are to immediately initiate with the district selection committee at earliest for undergoing special examination interview conducted specifically for this purpose as mentioned in point 4, and extension of pensionary benefit will be covered under Meghalaya Civil Service Pension Rule 1983 as per OM dated 21/12/2022 as mentioned in the point number 5, page 4 bottom.
Where's the order of this court?
Order of this court, my lord, that is in my read petition, page 10, my lord.
No, in your petition, yes, page 10.
Yes, in my petition. The origin
Who are
part
the
is
parties
page.
Director of Agriculture and the Assistant Agriculture Engineer, Your Lordship.
We have
didn't make the personal department
yes,
party.
we make a party,
No,
lordship.
Lordship.
Personal department not party.
Yep, yes, they are mega party.
They are
page 5.
responding. I apologize.
Respondent number 5.
You didn't make them party in the contempt application.
Contempt, we have not made them.
You are making this poor assistant agriculture engineer mechanical. What will he do?
File an application to implement.
See, if you want to file a contempt, you should have to at least study the matter and see how it to be done by whom. Understand? No, the question is filing contempt because this person, what can he do? Even if you put a sword to his head, also he won't be. He can't implement the order. Contempt relies people who are there in the seat of power, who have in their hand the power to comply with orders. And if they do not comply, there's willful violation, then contempt proceedings are drawn up. Not just to shoot in the dark at anybody to say there's contempt.
So I pray that I'll file an application to implement respondent number 5.
Your Lordship, here this respondent number 1 has also retired, Your Lordship, so she will
Doesn't
not be
matter.
able to.
Contempt is by person.
I may be allowed to just file a small
No,
application.
we're not here to give you a class on how to file petitions and what to do. Yes. Just after 3 weeks to enable Mr. P.T. Sama to make appropriate applications for improvement.
Lordship.
Obliged, Your Lordship.
What's place, Lordship?
Item number 3.
My lord, this is the non-grant of the disability pension.
No, see the last order, 5/2/2026. See the order last. You seen last order?
My lord, he wanted to file a.
Yes.
But I
That
have the
affidavit is still.
But here, my lord, a medical board was to be convened to assess his disability, my lord. Now, what happened, my lord? The instruction which I received, my lord, it was initiated, my lord, but there was some defect in the procedure, my lord. We have reconvened medical board, and he will be called to attend the.
You file. See, last time the courts allowed
Yes,
to choose your stage of compliance.
So just today I have received.
Dr. N. Mozika today praised for allowed further time to file an affidavit at least showing the stage of compliance of order of this court.
My lord, considering because the age of the factor, my lord.
Yes. Just after 2 weeks.
4.
In this case, Your Lordship, we are filing our affidavit in course of the day. The advance copy has already been served.
But I have filed an application that after filing of the writ petition, my salary was stopped for 7 months. Instead of replying to the notices issued by this honorable court, they have stopped my
Would the
salary.
managing committee?
Yes, my lord. The money has come from.
Appearing for managing committee. Mr. Marak appearing managing committee. Why you stop the salary? No, why you stop the salary? Where's Mr. Sheikh? I saw him somewhere around here. Next court. You're for 5 and 6. And you're for number 4. Yes, MST Yangi B and AAG submits that affidavit has been filed on behalf of the respondent 1 to 3. However, Mr. M.R. Marak for number 4 and MS for your 4 and number for 5 and 6. Please for further time to file affidavit. Stop. The senior counsel petitioner submitted that from the time the writ petitioner has filed. Oh, when did he stop the salary?
Arrear salaries of 7 months was released by the government. So other teachers got, and the moment they received the notice, they will stop me.
Submits that on receipt of notice of writ petition, respondent number 4 stop the salary, stop the payment of salary to the writ petitioner, which has put her
yes
into great financial distress. Stop, specific instructions to be obtained by respondent number 4 in this regard before the next date. Just after 2 weeks, yes.
Right.
5.
Yes.
May please, Lordship. Lordship, I am praying for some time,
Final
Lordship,
arguments.
to argue the matter.
Yes, you ready?
I am praying for some time, Lordship.
You are undertaken to argue the matter, correct?
No, Your Lordship.
No, you didn't undertake. What's the matter about?
Lordship, here we are challenging the MPSC recruitment process, Your Lordship, for the post of primary investigator, Your Lordship, / computer, under the Directorate of Economics and Statistics, Your Lordship.
Oh, yes.
Your Lordship,
Now
the
on your
matter
sheet
is-
you written no.
No,
You
I'm
know, then
on my OMA sheet,
how
Your
do you
Lordship.
correct that?
Your Lordship, I'm trying to find some authorities, Your Lordship.
See, once you write no, then one is an OMR sheet. So it goes to system as no.
Your Lordship, it's a bona fide mistake, Your Lordship. It's not.
So you are paying very heavy price for a bona fide mistake. You will get authorities.
Yes, Your
Yes,
Lordship.
there are some cases, yes. But see, on the previous MSGC Mavo, Leonard Council petitioner, please without some further time to
Look for
authorities in support of a case. Not objected to by conference for list after 2 weeks.
Item number 6.
Please, Lordship. Here I am praying to some more time to file my rejoinder, Lordship.
How many times you prayed?
No, this is second time.
Yes, just prayed for the 2 weeks time after joining. Yes.
7, 8, 9 are connected.
Yes.
7, 8, 9 are connected, Your Lordship.
7, 8, 9, same order.
Lordship. Must press, Lordship.
10.
Your Lordship, in this also we are filing our affidavit in course of the day, Your Lordship.
Who's for the petitioner?
Petitioner Mr. Siddiqui.
You were here just now. Yes, MST Yang EB, then AG submits that, you have to define the course of the day. Unless after 2 weeks for the joinder of any.
Obliged, Your Lordship.
11.
Respondents are yet to file their affidavit, Your Lordship.
I'm praying for 2 weeks time, Your Lordship.
Pension matter, Your Lordship.
Pension matter from GHEDC?
Yes, Your Lordship.
We are appealing for?
For respondent number 1.
You has no role here. You don't necessarily party, correct? You've been arrayed as party, you've arrayed as party, strike them off. Yes, MSE Dakhar. For respondent number 5.
4 and 5, Your Lordship.
4 and 5. 4 and 5. How much longer time?
2 weeks.
1 week enough.
2 weeks, Your Lordship.
Please further 2 weeks time to file affidavit. Stop. MSE, you know after from your side. MSZ in the 1 and 2 submits that as they're only formal parties, no affidavit before coming from the said respondents. Stop. Next, MSV Pasa submits that the point number 3, that is Accountant General bracket A and E Meghalaya, has been wrongly added as a party. So she prays that he is going to be struck off in the array of parties. The same objected to by Mr. Pasantia, for the petitioner accordingly. Point number 3 shall stand struck from the array of parties. Proceed with necessary corrections. This up to 2 weeks for affidavit by 4 and 5.
4 and 5.
Yes.
12.
What happened? You got some money?
Some of the petitioners are being paid, some are not being paid, Your Lordship.
Then how will the court pass orders then if some have been paid, some not been paid? Which ones have been paid? You strike them off as petitioners?
Your Lordship?
You strike them off as petitioners?
No,
Your
Your Lordship.
Then
No, Your
what do you
Lordship.
want today?
Your Lordship, here there are 2 petitioners, Your Lordship, here who are the present MDC, Your Lordship, and they are not being paid, Your Lordship. Respondent number 17.
Number 17?
Sorry, Your Lordship. Petitioner number 17 and number 23, Your Lordship.
Why will be paid pension when they're serving now?
Your Lordship, they had already served.
For the
and then-
arrears?
Yeah, Your Lordship.
That's a different. Yes,
Lordship, I'll take instructions, Your Lordship.
but you bring in a bill, right? To stop that pension altogether now.
Your Lordship.
Your Lordship, if that is the case, they have to pay till the time the
Yes.
act is repealed.
MS BF Karman,
Karwan
sorry, has submitted that certain amounts have been released to
petitioner.
which petitioners?
Lordship, except petitioner number 17 and 23. Your
All
Lordship.
of them have been paid,
All of them have been
except petitioners 17 and 23 who are serving MDCs. All the others, up to date, they've been paid.
paid. No, Your Lordship.
The other petitioners have been given some amounts
Your
towards
Lordship,
arrears.
they are being paid a meager amount of 50,000, Your Lordship.
50?
Lakhs, Your Lordship. Lakhs are pending.
Been
Period.
paid certain amount towards arrears of pension stock. He pays the matter after 2 weeks to wait for the developments. Yes.
Highly obliged, Your Lordship.
Lordship, item 16 is connected with this matter.
16 left together, yes.
Highly
15.
Yes.
13.
My lord, this is the case, Your Lordship, regarding advertisement. Our contention, my lord, this is basically to be filled up by promotions. So, my lord, no result, nothing. In this situation, affidavit has been filed. My only prayer, Your Lordship, can take it up for hearing, my lord. Fix a date and take it up for hearing.
What is there to be heard, my lord? First of all, another aspect of the matter is that the age also. He has not attained the age of 35 years old.
I'll satisfy
How
this.
old are you?
I'm below 35, just about to complete, my lord. Now, my lord, only thing, Your Lordship, these are the points I need to satisfy, Your Lordship.
Ambitious judicial officer.
I need to satisfy, Your Lordship. I'll satisfy, my lord. Post it for hearing, my lord.
We can't dispose it now.
Today. You can take it up tomorrow. No problem. I'll come ready.
What a Friday.
Any day next week, my
Anyway,
lord.
the results are going to be out also. Let it be after 2 weeks.
I'm very uncertain, Your Lordship. But let it be posted for hearing, well, after 2 weeks.
Let counsel for the prisoner praise that as the matter deserves detailed examination, it may be fixed for hearing. So, this for hearing after 3 weeks.
No, my lord, that will be too late.
2 weeks.
14.
My lord, this matter has been referred to mediation, my lord. We have received notices also. It's fixed on 14th of March.
Okay, I submit that the incident matter has been referred to mediation list after the proceedings.
Yes.
15.
My lord. So it will be completed, my lord.
The course of the day, Mr. B.K. Singh.
During the course of the day.
Yes. What about interim prayer?
Interim prayer may continue, Your Lordship.
There's no interim prayer.
Lordship.
There is no interim prayer, my lord.
The last
Interim order, sorry. Interim prayer is there.
On lasted, I missed out, Your Lordship. Kindly continue the interim order till
There's
next
no
day.
interim order.
Lordship,
There is only a prayer of interim order will take next day. Mr. B.K. Singh, counsel for respondents. B.K. Singh, correct? Can't see you.
Yes, my lord.
Blame me.
I don't know, my lord, why video is not coming up. Other.
It's from your side.
Yes, it is clear. I have made it cleared. I don't know why it is not coming up today. So, my lord, may I pray that the matter be taken up on 5th or 9th? We can dispose it of the matter, my lord.
Now it's what date?
Lordship,
5th.
Lordship, another matter was connected. Item number 707 is not listed today. It was listed on 10 March, Your Lordship. So I pray the
Let
matter
it come on
be
10
connected.
March.
Lordship.
Yes, Mr. B.K. Singh, Learned Counsel for Respondents 226, submitted affidavit. We find the cause of the day. Stop. Ms. Emre Rahman, Learned Counsel for Petition Service, that as another connected matters to be listed on 10th.
10th, Your Lordship.
3/2026. This matter is together. Prayers aloud. This
oblige my lord.
Matter with the advocacy number 707.
Oblige.
17.
On 10 March. Yes.
May it please your lordship. My lord, I have taken steps upon respondent number 3 and 4. I'll file my affidavit.
You already filed affidavit also?
Yet to file.
Yet to file.
Which time?
They've been served.
May it please, Your Lordship. Your Lordship, I'm appearing on behalf of respondents 3 and 4.
Very good. Yes. What's the matter about?
Lordship, this matter pertains to the release of compensation on behalf of the respondent number 3 and 4.
Okay, yes, sir.
That's
these are
by the
okay, yes.
My lord.
Right.
By the respondent.
Your Lordship, if I may submit, Your Lordship, I have been informed the respondent number 3 has been arrayed wrongly. We do not have any post as the president of Kurmaulong. He is known as the Rangbakur.
Fine. The president is English.
The head
name for Rangbakur, the head
of the court.
Sorry, your name, MS?
Arf and Lordship. I'm
Yes,
appearing on
MS.
behalf of Mr. A.R. Pasa, Your Lordship.
Yes, MS Arfankin, appearance today on behalf of respondents 3 and 4. Such service complete all respondents. When are you going to file affidavit?
1 and 2. 2 weeks, Your Lordship.
Stop. Next para MS Ailingwa for 1 and 2 and F1 for the 3 and 4. Prayer allowed 2 weeks time to file affidavit.
Oblige, Lord.
Let's stop. Also.
18.
This is a transfer matter. In the earlier occasion, my Lord Learned AG submitted that the invoked order passed by the Learned Division Bench in Philip Kraupukcha case. The instant transfer petitions are covered. My humble submission is, my Lord, it is not covered. It is a
Why?
distinguishable.
If that amendment is found to be all right, then
may submit that judgment. But the judgment passed in the Philip case, my lord.
The judgment?
Copy of the judgment is here, my lord. May I submit to the court master?
I'm bound with the judgment. Since it
Yes,
is
your lordship has been part of the.
My lord, it
But
was part of
that was not
bench.
my submission, my lord. What my friend is saying, this was my submission. My submission is not that, my lord.
You are bound unless it goes division bench. That's the correct position.
That is there, but that is my, because the transfer petition has been filed only on one ground, and ground is, my lord, that the district and session judge has no jurisdiction, my lord. And after I can show one paragraph only. That is the only ground taken up in the transfer petition. There is no other ground, my lord.
My lord, can you see
And
para 8?
BNSS, after notification of BNSS and CRPC, that issue is no longer alive, my lord.
Yes.
But early occasion, Lord AG refer to this. Para 8, my lord.
Yes.
On a plain reading of the 3 notifications, it does not appear to us that the governor has exceeded its jurisdiction in extending the provisions of the state code as sections on such PNNS 2023. The state government is entitled to extend the provisions of the state code to the tribal areas. The only conflict that arises is whether, by reason of the paragraph 5, subparagraph 3 of the 6th schedule, the provisions of the PNS and PNS would apply to the state. The notifications are carefully drafted as it would appear from the state notifications that paragraph 5, subparagraph 3 of the state notification has not been touched, and the constitutional rights enjoyed by the district council have not been impaired by the state notification. Moreover, by reason of the judgment of the Honorable Supreme Court in state of Sunset Solangpiao, in the absence of a notification by the state government extending CRPC to tribal areas, the provisions of CRPC are not applicable to tribal areas, except Chapter 8, 10, and 11 of thereof. The state government has now since issued notification extending the benefit of the state section to tribal areas. However, the state was carefully in not imposing upon the district council courts to mandatorily apply the provisions of PNNS and PNS. Now, according to me, my lord, here, so long as the conferment of the governor, conferment of para 5, 1 remain, not withdraw, my lord. District council designated officer has a jurisdiction. And in view of that, alive of that notification.
No, only jurisdiction, yes, but whether they have exclusive jurisdiction.
That is
that's the only question. Yes.
That is a contention.
That's the only thing that I mean, to my mind,
yes,
court's mind, that only whether it'll have only exclusive jurisdiction.
But according to me, my lord, it has exclusive jurisdiction, my lord. Without that, my lord, otherwise without that conferment, the district judge, the session courts has an exclusive jurisdiction on the para 5. But since the para 5.1 carve out a special provision that the moment governor exercised that conferment power, district council designated officer acquired that jurisdiction. And that jurisdiction is still alive with them. Therefore, my humble submission is, my lord, those are conferments, in fact, refer to 1937, led with 1960. Allowing appointing the additional deputy commissioner to exercise the jurisdiction of the deputy commissioner. And with regard to, my lord, the order passed in the Convergent case, regard to jurisdiction, Supreme Court has stayed that jurisdiction.
Regarding?
Regarding the order passed by the division bench in the Convergent case, jurisdiction with regard to the extent held by this honorable court, division bench, that session court in Nongpo has a jurisdiction to try cases coming from the tribal community. That is stated by the Supreme Court till today. So that Convergent case has no effect on these transfer applications.
There is no stay, my lord.
There is the stay order. May I just submit that?
Please,
whatever
you show us.
Upholding the conviction, still operating, because I accused did not prefer SLB. But this is a petition filed by the district council. May I come to para 6, page number 3, my lord. May I read with Lordship permission? With the above, the senior counsel submits that while the district council is not directly interested in the outcome of the session case number such 15, direction given the judgment, impugned judgment such upholding the said judgment is coming in the way of functioning of the competent district council court for trial of serious crimes in the jurisdictional area. The division bench of the High Court, while upholding the conviction order on the accused such by the session judge district, made the following observations. However, in view of the second paragraphs in both the notifications of December 10, 15 and May 3, 2018, the earlier notifications pertaining to trial of serious crimes within Ripoll district stands superseded, and the power previously conferred to the district council courts or particular officers can no longer be exercised to the extent it has been superseded. Part 38. For the reasons aforesaid, there is no merit in the objection raised by the appellant as to the jurisdiction of the trial court in this case to conduct the criminal trial, educate the matter, and pronounce a judgment or order thereon. In terms of the notification May 3, 2018, the office of the district and session judge, as specified in the Meghalaya Judicial Service Rules 2006, was vested with the power to try the present case as it involved a death sentence, and the appellant's challenge to such authority in vain. Well, Para 10 may come that. In the meantime, the operation of the observation in paragraph 34 and 38 of the impugned judgment order in criminal case number such are
so see, 34 says what? Says that, however, in view of the so-and-so, when it trial serious crimes when the Ripoll stands superseded, and the power produced conference council can no longer be exercised to extend.
So now, therefore, my lord, the division bench
has been made. Yes, the division bench said that. Then Supreme Court clearly this observation. How does it have a effect on this proceeding?
Earlier occasion, learned AG.
I did not make any argument. Please don't refer that.
Earlier, my lord. Earlier also he referred. He referred to that, my lord. In view of the order passed in the Commercial.
When you are caught, you will blame me.
My lord, my lord, may kindly see his affidavit.
Yes.
That is uncalled for. His own affidavit may I show the paragraph where he referred to Commercial.
No, fine. Now the thing is that
I'll please do the 2015-18 notifications, madam. It is with.
What's happened to the case now?
Well, may I just submit that notification referred by the division bench Commercial.
No, but that is the only part of the state is the part that that they're divesting the second court of their jurisdiction. If you understand correctly, correct? Now, what Commercial said.
Before Commercial, we argued that since the governor confirmed is there, session court has no jurisdiction.
See,
but the division bench have
conferred on district council courts can no longer be extended to extent has been superseded.
So, my lord, kindly see those two notifications.
Even then, this interim order of the normal Supreme Court, with due respect, would have no effect.
My lord, therefore,
it's just
my lord, therefore, the jurisdiction matter, judgment on jurisdiction is stayed by the Supreme Court. Therefore, my humble submission is that there is no restraint.
It's not stayed. It just says that. Because the division bench judgment said that it's been to extend superseded, can no longer exercise extend has been superseded.
By that judgment, to emergent case, the learned division bench of this oral court held that in view of that notifications, the session court has a session jurisdiction to try cases coming from.
During the pendency of the commission case, those other notifications were issued, correct?
No.
Yes.
No, my lord. During the pendency before this honorable court, that extension was issued.
Yes.
Therefore, may I just refer to page number 15 of that compilation I gave. Page number 15. These are the two notifications referred by the learned division bench in Commercial case. Page number 15, my lord.
Yes.
May I read, my lord? In exercise of the powers conferred under Rule 1A of the Rules for Administration of Justice and Police in the Khasi and Jindi Hills 1937, and further subparagraph 1 of subsection 2 of Meghalaya Autonomous District Administrative Justice Act 1960 as adapted and amended by Meghalaya and read with paragraph 5 of the 6th Schedule to Constitution, The Governor of Meghalaya, with the approval of the Honorable High Court of Meghalaya, is pleased to appoint Shrim Sansaj District and Session Judge Ripoy as the Additional Deputy Commissioner Ripoy District for the trial of all offences punishable with death, imprisonment for life, or imprisonment for a term of not less than 5 years under the Indian Penal Code, or under any other law for the time being applicable to the district, and also to hear all civil and criminal revisions, appeals, etc. from the decisions of the assistants to deputy commissioners within the said district. And the Governor is further pleased to direct that such district and session judge as additional deputy commissioner shall, for the purpose of exercise all the judicial powers of the deputy commissioners within the said district. This supersedes all earlier notifications issued under aforesaid provisions within Ripoy districts. So this was quoted, my lord. 2018 notification, also page number 17.
No. What do you want to show by this?
By this, my lord,
that only under 37 rules they've invested in power.
But therefore, the division bench in Kumarjan case held that in view of these notifications, superseding the earlier notification, Session Court in Nompo has the competent jurisdiction to try the cases. Therefore, conviction against Kumarjan is upheld.
Yes.
So jurisdiction also upheld, and conviction also upheld. And the jurisdiction
the only thing is that to the extent been superseded, that's all.
But
it's been superseded as per para 34. So that means that extent superseded, maybe the interpretation of this notion was not, really what. See, what it says is, now you read from the top.
Yes.
Under Rule 1A of the Rules for Administrative Justice, Police.
Yes.
937.
Right.
And further under Section 2 of the Meghalaya District Administrative and Justice Act.
Yes.
As of Meghalaya, read with paragraph 5-6 schedule of the Constitution. So under three heads, powers invested.
Yes.
And adapt amendment so read paragraph 5, right?
Minor.
With approval of the High Court of Meghalaya, SPs appoint as Session Judge Ripoy as additional deputy commissioner.
Yes.
So the additional deputy commissioner will come under 37.
Yes, 37.
To trial all offences punishable with death, imprisonment for life, so and so. And then it comes to
allow them to hear all civil and criminal visions.
As additional deputy commissioner for a trial of so and so, yes. And the 2 lines from the paragraph, within the said district and the governors further please to direct such sessions judge as additional deputy commissioner shall propose and exercise all the judicial powers of the deputy commissioner in the district. Right. This supersedes all the notification issued under first provision in the Ripoy district. So, by your understanding, what does this imply? This notification. What kind of vestment of power is done on the district session judge Ripoy?
In fact, my argument for the learned division bench was that this notification was in fact appointment of a district session judge as a additional deputy commissioner from 1937 date with 60, not from the para 5. That was a blank argument.
No, that has been rejected.
Because that is it. Because the para 5 do not contemplate the hearing of civil and criminal appeal or revisions. Para 5 confirm and exercise the original jurisdiction. There is no question of filing appeal against before the designated district council officer. Now, therefore, we argued, though it is rejected.
See, once a trial is committed to the court of district sessions judge, it is the original jurisdiction exercised by the court with regard to these offences under above 7 years.
That's the point. My argument for the 11th division bench is that this confirmation is with regard to the appointment of a district session judge as a additional deputy commissioner to trial cases regarding the non-tribals. Because for tribal,
that argument was not accepted.
But that was rejected.
Now,
so,
what now? That was rejected. Now, with the order of the Supreme Court, how does it change things?
Therefore, I'll just
try to satisfy the court.
But therefore,
why the interim order operates now?
Yes.
That the paragraph 34 of the judgment has been stayed.
Yes.
Correct. Yes. Okay.
Therefore, it is since it is stayed, the confirmation issued by the governor is alive. Confirmation given to district council officer to trial cases of session in nature.
There's no quarrel with that, because even with the subsequent notifications that came out, that means the powers, the jurisdiction of the council is still protected.
Therefore,
yes.
Therefore, since it is protected and safeguarded by the governor conferment, the cases relating to tribal require to be transferred to the designated officers. That is the contention in the transfer applications.
Right.
Transfer application. And this page number 17 also. That superseded 2015 notification. The same language, my lord. In here, they appointed district and session judge. In my lord, para 5, when we read para 5 of the 6th schedule, there is no appointment. There is no question of appointing the district session judge on the para 5.
There's a question of?
My lord, appointed. Para 5, my lord. My lord, may kindly read with me paragraph 5.1 of the 6th schedule.
Yes.
My lord, the governor may, for the trial of suits or cases arising out of any law in force in any autonomous district or region being a law specified in that behalf by the governor, or for the trial of offences punishable with death, transportation for life, or imprisonment for a term of not less than 5 years under the Indian Penal Code or under any other law for the time being applicable to the district or region, confer on the district council or regional council having authority over the district or region, or on courts constituted by such district council, my lord, and or on any officer appointed in that behalf by the governor. Such powers under the Code of CPC, or as the case may be, Code of CRPC, as it deems appropriate, and thereupon the said council or a court or officer shall try the suits or cases offences in exercise of such powers. So confer. So the governor can confer to three authorities, either district council, regional council, or court constituted by the councils, or officer. Now 2018 conferment is so-called conferment, according to the view of the respondent, is that they have appointed district and session judge.
Now come to this is also that I was always curious about this.
Well,
now it says that confer on the district council or the regional council having authority of such district or region, or on courts constituted by such district council, or on any officer appointed that behalf by the governor. Will this any other officer appointed on behalf of the governor mean it has to be the judge of the council court, or it can be any other officer? That is one thing which always I was always curious about the interpretation of this. Whether will it mean that that any, or he says no, any or on any officer upon that behalf by the governor, whether that will be outside the scope of with leaving this whatever arguments we have with regard to them this case. Now whether fine, vesting of powers, conferring of powers by the governor can be in regional council, district council, the courts made by the district council, or on any other officer.
Yes,
would that
if
mean,
Lordship kindly see the
can it be any officer? That means can the governor, for the purposes of confirming the para
even this judicial,
take up Mr. Changreso to exercise his powers?
If your Lordship will kindly
give the governor that power.
Your Lordship kindly see the expression used, my lord, third line, the confer on district council. Lord, kindly, district council, your Lordship has this, or regional council having authority. So conferment can be on district council itself without any officer, my lord.
Right. Or the regional council.
Regional council having authority, or courts constituted by such district council. So it can be on
behalf by the governor will mean in that behalf of district council, in that behalf for conferment of powers.
So if your Lordship will kindly break this district council, so conferment will be on district council or regional council. One. Second category, on courts constituted by district council. This will be second category, my lord. Third, any officer appointed in that behalf the governor. So the power to appoint officer will be by the governor, not by the district council. District
exactly on that behalf. Now, will it mean that the governor can pick up Mr. Mansoori to trial the offence of 5 years?
No, that will not be there. That will not be there. But that will not be there because
I'm just giving a supposition.
Yes, my lord.
Suppose he says, district council, regional council, then on the courts, and third
category is any officer appointed in that.
Can be appointed.
For example, the appointment of district and
or does it have to be an officer of district council? That's what this code
will not, because if the constitution wanted that it has to be officer of the district council, then it would have said so, because when it's saying that conferment can be on district council itself. Even district council can also decide the matter. A court constituted by district council can decide the matter, or my lord, officer appointed on that behalf. For example, on that behalf, your lordship, which is troubling your lordship, is that the district and session judge is also deciding the matter, and he is also appointed by the governor. And those conformant notifications, which that is the conformant notification under when BNSS was
in a way because.
Yes, Lordship is right. Yes, Your Lordship is right. So when there was no Your Lordship knows that when there was no CRPC notification, district and session judge in Garo Hill, in Jantia Hills, in other parts where there was no similar notification, were exercising the power by virtue of notification under paragraph 5 only, my lord. Like in Rivoi district, that was power, was the only part which has been stayed, saying that to the extent district council power was excluded by those notifications, that part has been stated, saying that yes, if district council has been conferred power under paragraph 5, it will continue to exercise, and as well as Rivoi district, the district and session judge Rivoi will also continue to exercise the power. So there is no conflict, my lord, in my humble submission. It's very clear. And after this Philip Corbach Sati, my lord, this order, my lord, if I please one paragraph only, one paragraph.
Is my table for 6
because what was challenged?
I think I have that 6 book on my table, the latest edition. Yes.
What was challenged before your lordship?
Before we go to Philip Corbach judgment,
only 2 minutes. That's my mind.
Yes.
Now any officer, now the governor, because the governor exercises very special power.
But this issue will not arise also, my lord.
With regard to appointment, is not like any other governor. Now on a 6th schedule. On a 6th schedule, yes. On a 6th schedule.
But now, my lord, if I submit, my lord, this issue may not be there for one reason, my lord. One reason is that now notifications have been issued under BNSS conferring power on the district and session judge.
But let us just rewind a bit.
Yes, my lord. If I go back, my lord,
just rewind a bit, because understand the genesis of,
yes, my lord,
whether the constitutional security itself has envisaged this kind of situation, and whether these notifications are in line with the paragraph 5,
yes,
or whether these courts, whether it's exclusive, the exclusivity.
No, my lord. So in that the question is that the constitution did not say that they will have exclusive jurisdiction, my lord. There is a conferment on the district inherent jurisdiction in paragraph 4 only, my lord.
I've seen the parliamentary debates in the Constitutional Assembly while framing the 6th schedule.
To debate, interpretation, there is a confusion in the provisions.
There is no, my lord, deliberation in the Constitutional Assembly that the officer should be from particular or from the district council.
One second, Mr. Karuso, just give me 2 minutes. Does not clarify. Even this the book is, it does not really clarify. It just says that yes. You've seen this status.
Well, I've seen
regarding that. This is the author's note.
Yes.
The Supreme Court has stated operation paragraph 34 and 38 of the High Court judgment, and the case pending consideration.
Yes.
The author is of the opinion that the High Court failed to notice that there are 2 separate set notifications issued by the governor, one under Amsterdam Justice 37 and other under 53. Which has to answer conferred region so. I deputy commissioner with other rules on the council court to conduct trial of case punishable so. Both notifications operate in different fields. That's why notification of 37 rules are for conduct of trial cases, and then rules and notification under 53 rule for a trial case where both parties scheduled trial. But the thing is that is again on that behalf by the governor, whether the district session judge will come within the meaning of that appointment done by governor at behalf and conferment of power of that paragraph 5. The paragraph 5 speaks specifically only about 5 years. is very specific.
Yes.
It's not like paragraph 4, which is very clear.
Yes, yes.
The paragraph 5 is very clear. So if that exception, if that, is there in the Constitution section itself. Anyway, yes, what are you saying?
Therefore, this issue is such very serious that it's a heavy duty for us also to assist my lord, so that lordship can adjudicate the issue, my lord, judiciously. When we see the history of the conferment, which I've submitted the compilation, my lord, Governor, my lord, will see the compilation I have given. Good. First, conferment, my lord. There are 4 types of conferments are there, issued by the governor, my lord.
And it's not so simple also as saying that, you're conferred under 37 and the conferment is under 53.
Yes.
That they are parallel. That is not so simple to interpret it that way also.
My lord.
With due respect to the author also.
My lord. And
what do you say?
Exactly,
It's not so simple.
So
to say cut and dry. Okay, 37. You exercise only powers additional deputy commissioner. You try in cases with one of the parties on tribal, and then so you are limited to that. And as a council, since the other 5-1, you have invested powers 53. So you tried it under
37 rules, 60.
53. That means it limits to district council court, and 37 is for trial of 1 non-tribal or 2 non-tribal. So those are
my lord, that situation is now no longer prevailing, my lord. My submission is one, my lord.
No, we go there, yes.
Yes, because that is the only ground. If we need to go back into those notifications, my lord, then the question is whether the district and session judge, as on today, is deriving his power by virtue of notifications under Khasi administration of justice rules or not. Khasi and Janti administration. He is not derived. Right now, there is a notification under BNSS and CRPC. So, and the
extending this
and the power of district and session judge, my lord. So, therefore, in my humble submission, my lord, we may not go in that route because my friend is required to establish one fact for transfer, my lord, which your lordship has aptly put in the beginning. You show me the provision by that the district council court has exclusive jurisdiction to try the case. That is the issue. If the district council court has no exclusive jurisdiction, then my friend cannot.
That is what by the notifications that have come.
Yeah, and those notifications, assuming I take
exists.
Yes, and I take his case at the best, and I argue against myself, my lord, that yes, there is a conferment on district and district council courts to try the cases and cases also by virtue of notification, my lord. But at the same time, your lordship, the notification is also conferring power on district and session judge appointed by the governor, my lord, and those notifications have been upheld by the division bench, my lord. Once there is a power to try the cases session trial, my lord, earlier when Komarchand case was there, my lord, there was no such power. So that is the fundamental watershed development in the entire perspective, and only ground which is taken, my lord, that the district council court, if your lordship will see one paragraph only in the petition, only one ground which has been urged before your lordship is that 11. This is the case of, my lord, this synopsis, if your lordship will say, I will read out. It is humbly submitted that though the present status of has reached the examination of at least 11 witnesses out of 15 witnesses projected by prosecution, it is undisputed in view of the paragraph 4 and 5 6 schedule, the present trial court did not have the jurisdiction over the subject matter. So the only ground is that in view of paragraph 4 and 5, the district council court the district session judge has no jurisdiction to try the cases, my lord. And your lordship has seen in paragraph 5 there is no such thing, my lord. And your lordship has seen that BNSS notification has been upheld by this honorable court. They challenge that BNSS notification, and that we so therefore, if the matter has to be transferred from court of district and session judge, it has to be held by your lordship in the transfer petition that district and session judge has no jurisdiction to try these cases, my lord. And wherever there is a notification in paragraph 5, only district council court has the jurisdiction to try the cases. That is the limited issue, my lord, in my humble submission.
I'm making an effort to make out that ground. Well,
distinguish.
Well, lordship, kindly take the pain to see the copies of notification I have furnished, compilation.
Yeah.
It is quite instructive, my lord, to see, my lord, how the governor used to exercise the power of 5-1.
Your power of
compilation. Yes. 1989 confirming. page number 1.
Yeah.
It says, my lord, exercise of power conferred by paragraph 1 of paragraph 5 of the 6th schedule of the Constitution of India. The Governor of Meghalaya is pleased to confer, Sri such council who is hereby appointed by the Governor. This is the language of the 6th schedule, my lord. As the officer for the purpose of aforesaid paragraph, the power for trial of offences punishable with death, transportation for life, or imprisonment for a term of no less than 5 years. This is exactly, my lord, the sentence was lifted from the 6th schedule, my lord. There is no confusion.
No, how right this is also, we have reservations. Anyway, you continue.
The next page, para 2.
Because once he is already a court, constituted by district council, you don't have to say, because the thing is that what the government had done is that they have made it persona designator, in the sense that they have named the officer. That is why, so an officer appointed, the persona designator, that's why they've given to Mr. So-and-so.
Therefore, exactly this is the third category of the para 5.1.
So that means that this notification considers his persona designator is the person
in person,
himself, not the court.
Not the court.
Yes.
As an officer, in person. And if he retires or transfer, my lord, whoever comes in the same chair will not exercise the same power.
Right.
But this the page, the second also same thing, my lord. I would continue, my lord. I would read the entire thing. Then I would come to, my lord, page 5, my lord, para 5.1, my lord. Page number 5.1.
5.1.
5.1, man.
Yes.
5.1. The second paragraph. Further, the Governor of Meghalaya is in exercise of power conferred under subpara 5.1.5 of the 6th schedule of Constitution in the use of please to confer citizens and such Shillong the power to try offences punishable with death, transportation for life, imprisonment for such. So they never quoted, the Governor never quoted 37 rules, 1968. Never quoted that one. It's only exclusive.
Never quote, you mean they've quoted 53 rules? They have to be under 53.
My lord. Therefore, my lord. Here.
37 won't come when it concerns district council court judges.
My lord. 37 doesn't come into play.
Not at all.
Not at all. Exactly. So there is no confusion with regard to this conferment. Now, second category of appointment, the conferment, may I show page number, my lord, 6 to 12 are the, my lord, another notification, my lord. This is exactly the correct conferment. Para 6 onward, my lord.
1 second. Page 6.
Page 6. This is the correct notification issued by the Governor. In exercise of powers conferred under Rule 1A of the Rules for Administrative Justice and Police in the Khasi and Jante Hills 37, and further under Section 1 of Section 2 of the Meghalaya Autonomous District Administrative Justice Act 60 as adapted amended by Meghalaya, the Governor of Meghalaya, with the approval of the Honorable High Court of Meghalaya, is pleased to appoint Sri Dipna District Session Judge as the Additional Deputy Commissioner for District for the trial of offences punishable with death, imprisonment for life, or imprisonment for a term of not less than 5 years under the Indian Penal Code or under any law for the time being applicable to the district, and also to hear all civil and criminal revision, appeal, etc. from the decisions of Assistant Deputy Commissioners within the said district. And the Governor is further pleased to direct that such a district and session judge as additional Deputy Commissioner shall, for the purpose of her said, exercise all judicial powers of the DC within the said district, including session cases of Sura Sansad with immediate effect. All appeal from Sura Sansad. But this is the accurate appointment, exercise of power under 3760. Here he did not quote para 5.
So fine, now they've brought in para 5.
Now they brought in
dimension has changed.
Therefore, my lord, this conferment is purely.
See, with this conferment, that means that exclusivity is there, is maintained, correct?
My lord,
but then now these have been superseded by the notification. Now, what is the effect of the supersession?
My lord, therefore, my contention is that this is the conferment allowing him to try cases not under tribal. Or one tribal, another is a non-tribal.
Exactly.
This for this purpose.
There's no quarrel with that. What we're saying is that fine, under 53 rules, that's the council court and vested power. Correct?
Yes.
Like you, the other novel you read. This Amso Justice, the 50 rules that concerns the council courts. Now the 37, it's Amso Justice. This is a regular courts, you can say.
Yes, regular court.
Correct. There's no quarrel with that. Now the only thing now is whether with the other notifications that have come, whether exclusivity of this council is gone, whether both courts have sort of parallel jurisdiction to try these cases, because to the extent that power of this council court has not been touched by subsequent notifications. Now CRPC has been extended. So what will be the effect now, on the answer of justice in a particular district? Now whether the only question is whether now only the district council will still have exclusive jurisdiction, or whether by the notifications now extend to CRPC and investment of powers under para 5 on the district session judges, whether they also have concurrent jurisdiction.
Well, my humble submission, there cannot be concurrent jurisdiction, my lord.
They can, but then you have to show the.
I have to show
that's why the court that there cannot be concurrent jurisdiction, and this you think this is the correct notification? Yes, it's correct, but specifically under 37 rules. But then if it's confirmed under para 5 and then with the subsequent notifications that have come, extension of your BNS and BNSS, and so what is the situation?
Well, my humble submission is.
Can you say that the council still maintains exclusive jurisdiction?
My humble submission, district council, so long as that confirmation is not withdrawn, revoked by the governor, they exercise their jurisdiction, and therefore district session judge confer, my lord, subsequently cannot try the cases where both the parties are coming from the same scheduled tribes. They can try cases where non-tribals are involved.
That argument is an old argument.
Otherwise,
what we're seeing now in the current scenario,
yes,
keeping in mind Komarchan also, keeping in mind the latest judgment of the division bench also, where those notifications have been upheld. So where does that leave us?
My humble submission, even if my lord, they extended PNSS in the tribal area, as well as read with this 2015-18 notifications, district council court has exclusive jurisdiction with regard to particular parties. My lord. But that is exercised by the governor. If the governor withdraw it, my lord, I have no case. If the governor withdraw it,
different thing. In Jayante Hills, they don't have powers. They've not been conferred with powers to try for 5 years.
Yes,
not in Garo Hills, I think.
Garo Hills
so
also
now
no
it goes to regular courts, fine.
Yes.
Then suppose there's no conferment power to the council court. What happens to the cases if those regular courts can't take up matters between two tribals? What will happen to criminal cases arising from there?
But in Garo Hills or
in Jayante Hills?
In Jayante Hills, by the normal courts.
Why?
Normal court will continue. Under my lord 37, 60, the rule is still there, my lord. And they also adopted district council, that 37 rule is applicable in the Jayante Hills and the Garo Hills also. Because of that, my lord, they are trying.
Right.
They're trying because that is not conferred to them.
Then, if they confer under para 5 also here, so why should you stop them? You see, under 37, they should do it exclusively again on tribals here.
But therefore, in Garo Hills and this Jayante Hills, there is no concurrent jurisdiction. Only one court is exercising.
Right.
In your absence of conferment. But here in Khasi Hills.
So conferment is also confirmed for the council courts here to try for 5 years. Now with this notification where you come to the notification, which is the question.
Well, in my compilation, I've
come to...
I've put the... My lord, we come to page number 21.
Yes.
This is a conferment. Sorry, notifications. Extension, my lord. Made my lord. In pursuance to full separation of judiciary from the executive and exercise of power conferred under proviso to subsection 2 of section 1 of the CRPC, the Governor of Meghalaya is pleased to apply the provisions of CRPC to the courts, but it is important to the courts in the state of Meghalaya. The District Council Court shall continue to rewrite powers under para 5.5.
Your 4 and 5, under 4 and 5.
My lord. Now, by going to this, my lord, since they have protected the para 5 and 4, District Council Court can still exercise the power, exclusive jurisdiction over the tribals. If they do not retain this, my lord, one can say, my lord, subject to lordship correction, one can say that subsequent earlier notification conferred to the District Council officer subsequently, my lord, superseded. And this notification is taken away. But the governor has expressly provided.
See, because you can't go over and above the constitution, correct? So when notification is issued to enable certain kind of administrative justice, it has to come and be in line with the constitution. That's why if the constitution has given that power to the governor and he feels it fit to confer, already power to confer, that means those powers are protected. But not a protection of power where they make it exclusive. That's the only question.
my
whether
humble,
like protection of those, whether conferred powers on the regular courts under para 5, and whether protection also will be, at odds. That's the only thing. And whether exclusively the council exercises exclusive jurisdiction to try matters.
well, with profound respect, my lord, my humble submission is, my lord,
no,
no, my lord, there cannot be a concurrent jurisdiction. If otherwise, my lord, if we go by these notifications, two courts are functioning, my lord. District Council designated officers also trying the death sentences, session also trying the death sentences. In one state, two concurrent jurisdictions are there. But this cannot be the object of the sixth schedule. This cannot be the intent of the sixth schedule. Because sixth schedule is a constitutional compromise, my lord, concession given to the nature of the situation here in the state, my lord. My lord, therefore, this compilation I have given, and if the only defense made by the state in this transfer application is lordship, kindly say para 16 of the affidavit filed by the state. It is stable. It is my duty to clarify, my lord.
Yes,
my lord, I am trying to clarify, my lord.
Of course, we all, it's all, we're looking for clarification only. The 16 is a very grey area.
What? At the first instance, my lord, therefore, when we refer to Gomarjan, the AG said that he never argued, he never break up that issue. Let's see his evidence, he argued earlier also, para 16. Para 16, page 7, para 16.
Yes.
It says, my lord, that it is submitted that the issue of competence of the district and session judge is considered to try the cases by virtue of notification issued by the government, and the rule is no longer res integra, inasmuch as division bench of this honorable court in the judgment rendered in the criminal appeals under title Gomarjan Singh versus State of Meghalaya on is held in similar fact situation. The district session judge Ripoy district is denoted of the power to try the cases where victim and accused are belonging to the scheduled tribe, Khasi tribe, and residing in the areas of KGTC. In view of the judgment of the division bench of the court, which binds the parties and the learned singer judge, the transfer petition is liable to be dismissed. This is the ground, only the ground they have taken. Now this issue, jurisdiction, I'll come. Well, I'll come. Therefore, the submission at the first instance that I break up this Gomarjan issue absolutely against the record.
Yes.
But this is a different, and in view of the Supreme Court stay, but this jurisdiction issue in Gomarjan
is open again.
Yes, it's open again.
Okay.
It's open again. And para 19 referred by the AG, but he is referring that notifications. That it is submitted that fact situation has arisen, change in as much as state government.
Where are you reading from?
Para 19, page number 10. Para 19.
Yes.
Situation has changed in as much as state government by notification 2022 has extended the CRPC to the courts in the state of Meghalaya. In view of the extension of CRPC to the court of Meghalaya, and coupled with the fact that under the existing constitutional provision of rules for the administration of justice and police since 1937, and also the saving clause in 2022, the trial of cases by district and session judge for offences punishable with imprisonment for a term of no less than 5 years is well within the jurisdiction. Therefore, what they are trying to say, according to me, there can be a concurrent jurisdiction. Two courts can function in view of the extension. Which is not in the intent of the governor when he exercised para 5.1. There will be completely chaos and confusion.
So now, Mr. Chari, so suppose we accept your view, would it be at odds with what's now Supreme Court, the matter sees the Supreme Court also?
Well, that Supreme Court made a Solang judgment also there, and that Gomarjan is still pending.
Longpeo is on a different footing. Longpeo at that time said if the state had notified, it would have been a different proposition. Now the state has notified. Now.
Yes.
So how will Melvin Longpeo help you?
But therefore, my lord, that extension of CRPC is one factor, my lord. But
yes.
They expressly governor.
Now, even in Melvin Longpeo also, it was not brought to the notice of the whoever argued the matter was not brought notice of the Supreme Court as the exact ground situation. So in most cases, when counsel not properly briefed, they don't know the subject matter. So courts also they depend on assistance of the counsels.
Oh, yes, yes.
That's what happened here. That's what happened in Melvin Longpeo. That's happened in some other cases with regard to even that other matter that where it's a tribal residing from that district, and that is due respect.
So this issue perhaps may be addressed by the Supreme Court in that pending Gomarjan case also. this issue may also addressed by the
It's have an
Supreme
impact for
Court.
sure.
But as of now, what the law holds the field is the governor's notification till today. And this 2022 notification did not take away the governor notification. Rather, he expressly mentioned that District Council retained para 5 and 4 powers. And when I read with para 5.1 this notification and the earlier conferment, District
From the
Council.
last judgment of division bench then, where they've talked about that also, I think, about that, the protection of the jurisdiction of the Council Court.
Paragraph 8 million.
Yes, what does it say?
In that Philip's judgment, my lord is referring to Philip's judgment.
Yeah, that his name is Philip. Yes, Philip. Yes. Para 8.
Para 8, my lord.
Yes.
May I read it with lordship permission, my lord?
Please, please.
But on plain reading of the 3 notifications, it does not appear to us that the governor has exceeded his jurisdiction in extending the provisions of the code as such and such 2023. The state government is entitled to extend the provisions of the state code to the tribal areas. No confusion. The only conflict that arises is whether, by reason of paragraph 5, subparagraph 3 of the 6th schedule, the provisions of the PNSS and PNS would apply to the state. The notifications are carefully drafted as it would appear from the same notifications that paragraph 5, subparagraph 3 of the 6th schedule has not been touched, and the constitutional rights enjoyed by District Council have not been impaired by the said notifications. Moreover, by reason of the judgment of the Honorable Supreme Court Solong case, in the absence of a notification by the state government extending CRPC to tribal areas, the provisions of CRPC are not applicable to tribal areas, except para such and such thereof. The state government has now since issued notifications extending the benefit of the said section to tribal areas. However, the state was careful in not imposing the District Council courts to mandatorily apply the provisions of PNSS and PNS. That argument was, in Philip case, the argument was different. We relied on the subparagraph 3. Because one subparagraph 3, it prohibits the application of paragraph 5.1 once exercised. That in that context, this was rendered, my lord. And here, division bench has quoted that notifications. It retains, my lord, the power of District Council is acknowledged. So combined reading of the governor earlier conferment read with this extension of PNS, my lord. District Council, so long as my lord conferment alive, have a jurisdiction with regard to particular categories of litigants.
What is the impact or extension of this BNS and BNSS?
But therefore, here would criticize my lord. Here, the later part of this paragraph, it says not mandatorily applied. But this is another issue, my lord. Another issue. But now, my lord, District Council court will follow the procedures, my lord. But with regard to the powers, my lord, procedure is one thing according to my humble submission. Procedure available in CRPC is one thing. Power is another, my lord. So long as power is, my lord, conferred to governor to the District Council officer, District Council officer will exercise that power. But the rest, my lord, District Session Judge will exercise power under the CRPC.
Yes.
And I will place the rules only, and I will raise my submission.
1 second here. Yes.
My Lord, kindly see my compilation, rules compilation, page number 9.
This is a
compilation of the rules, my Lord. 37 rules, 60s, 1950s. First one is the notification. This one is the rules. Page number 9, my Lord. 37 rules. Page number 9.
Yes.
Rule 1A, my Lord. This court, my Lord, the governor may, when he thinks fit, appoint an additional deputy commissioner, either generally or for the trial of a particular case, or particular cases, civil and criminal, and may direct that such additional deputy commissioner shall, for the general or special purpose of a seat, exercise all or any powers of the deputy commissioner. Under this rule, my Lord, he tries all the parties. It doesn't matter tribal, non-tribal, my Lord. This continues, my Lord. And my Lord, we come to page number 19. Same ships, my Lord. Kasi same ship administrative justice order 1950. Lordship is well versed with this, but for my Lord side, I want to place, my Lord.
Yes.
Subsection section 2 was appointment of deputy commissioner. This continued, and the appeal is provided there. Page number 21, appeal. And I would come to, my Lord, page number 23. In fact, I have read the, my Lord, subject to Lordship correction, read the 6th schedule and the this rule. I was wondering how the concept of 5 years imprisonment above a trial comes into my Lord. Perhaps the Constitution derived from this section 16, my Lord. Subsection 2, my Lord. The court of CM.
Because that those times those CM courts were vested with powers of first class magistrate.
Yes.
So they exercise powers, and the District Council also recognize them as additional subordinate council courts. It's a code of. So that is why. So above 5 years, below, I mean, those are petty offences which they try. Yes.
My Lord.
Yes.
My Lord. And Lordship is correct, my Lord. That is, my Lord, supported by this subsection 2.
Yeah.
The court of CM may try any offences under the Indian Penal Code or any other law for the trial being enforced within its respective locality, except those punishable with death, transportation, or involving a punishment of 5 years imprisonment, which may arise within the limits of its locality, in which the Qazis who reside or hold land within its locality are concerned, provided CM's court shall have jurisdiction over non-Qazis who voluntarily invoke or submit to its jurisdiction. That is the 6th schedule is, my Lord. Therefore, para 5.1 perhaps lifted from here the concept of this, my Lord. And the
5 years.
My Lord, 5 years.
Yes.
Because this is a pre-constitution rules, 1950, my Lord. And the last one, may I come to para 60, my Lord, 64. Page number 64. By virtue of para 4, my Lord, under this, my Lord, all the cases are transfer. But section rule 4, rule 2, transfer of certain cases. So here, referring to para 4, paragraph 4 of 6th schedule, is the duty of this.
Under para 4,
undisputed, madam. That is undisputed.
Under para 4, all has automatically has to go. It's only confirmed under para 5, which is question in our case.
Yeah. Exactly. The last page, number 90, madam. I refer to this. 90, madam. Because the governor has referred to these rules.
Yes, 90.
90, madam.
Yes.
90. Rule 2, may I read, madam. Appointment of additional deputy commissioner. Notwithstanding anything contained in the rules for administrative justice and police in the autonomous district as adapted and modified by the Assam Autonomous District Census 952 as in force of the time being or any other law in force, the state government may, when it thinks fit, appoint one or more additional deputy commissioners for an autonomous district, either generally or for the trial of a particular case or cases, criminal cases, or may direct such an additional deputy commissioner shall, for the general or special purposes, aforesaid exercise or any of the powers of the deputy commissioner. Therefore, my humble submission, Governor, referring to this with the intent to appoint the district judge as an ATM to try those parties who are non-tribal. That is the intent, my Lord. That is the intent. not to take away the governor his own confinement. Till today, he is not revoking. Till today, there is no notification that his confinement is superseded. No notification is there. Therefore, my humble submission, there cannot be concurrent jurisdiction, two criminal courts in the one districts. That will be, my lord, lead to breakdown of the criminal justice delivery system. It's a serious issue, my lord. As I submitted, my lord, if the governor withdraw or revoke his confinement, ultimately, ATM will continue to try under 37 and 60. No one disputes, my lord. But so long as confinement is there, but it is the exclusive jurisdiction of that designated officer. So my humble submission is, Lordship, kindly consider the matter and admit the prayer, my lord.
Lord, only two submissions, my lord. One with regard to paragraph 16 of my counter affidavit, my lord. Kindly come to paragraph. Commercial judgment, my lord, and stay, in fact, support my case that the jurisdiction of district and session judge Rivoy has not been taken away, my lord. Kindly see paragraph 16 and the stay granted by the Honorable Supreme Court in paragraph 38 and 39.
Paragraph 30 of the affidavit.
Paragraph 16 of my counter affidavit, which was read by my learned friend, my lord. Give me
Even then, it's still very vague.
I'll just explain, my lord. My friend has not denuded, has not read it. He's read denuded. But I did not intervene, my lord, that point of time.
Paragraph 16,
Paragraph 16 of page 7 of my counter affidavit, my lord. Lordship, kindly see. By virtue of notification issued by government under rule is no longer res integra, in as much as division bench of this honorable court, in judgment rendered in criminal appeal number so and so, held in similar fact situation that district and session judge Rivoy district is not denuded of power to try the cases.
Yes.
So this issue, this has not been stated by the Honorable Supreme Court. What has been stated by the Honorable Supreme Court is that the observation in paragraph 38 and 39 of Commercial, which said that
34 and 38.
The 34 and 38, sorry, just give me the order. 34 and 38 of the 34 and 38 of the Honorable Supreme Court judgment is that in respect of that there is no power in District Council Court. So even as per Commercial, your Lordship has held that District and Session Judge Rivoy has the power. In Commercial, your Lordship also held that the power of District Council has been superseded.
Yeah.
To that extent, the Honorable Supreme Court said, no, it has not been superseded. To that extent, I have no difficulty that stay is operating. And that means that District and Session Judge, District and District Council Court are also having power. So that is one aspect. So therefore, as on today also, District and Session Judge, by virtue of old notification of 2018, my lord, they have the power to try the cases, if I do not bring the new notification. Now, coming back to, my lord, paragraph 4 and 5, my lord, if your lordship will find, there is a very unique distinction in paragraph 4 and 5. Because that I have been noticing for long. In paragraph 4, my lord, the District Council Court has been conferred with the exclusive power to try the cases where parties are belonging to scheduled tribe, my lord.
Yes.
Paragraph 4 clearly says, if your lordship will kindly see this. If any within district may constitute village council courts for trial of suits and cases between the parties, all of whom belong to scheduled tribe within such area. So the expression used or applied in paragraph 4 is that but there is no such expression so far as paragraph 5 is concerned. Even the district council court can try the cases between tribal and non-tribal, because there is a distinction. In paragraph 4 it says all, and if you lordship will kindly see paragraph 5, my lord. The governor may, for the trial of suits or cases arising out of any law enforced in autonomous district or region, being a law specified in that behalf by governor, or for trial of offences punishable with death, transportation for life, imprisonment for term not less than 5 years, or any other law for time being applicable in district or in conferred district. So it is not saying that District Council Court, when trying the cases in respect of these heinous offences, the persons have to be scheduled tribe belonging to. In paragraph 5, it is missing, my lord. As a matter of practice, what has been happening, my lord, that cases belonging to scheduled tribe only, they have been getting referred in district council court. But so far as paragraph 4 is concerned, it has the district council court has the exclusive jurisdiction, my lord. That jurisdiction cannot be taken away. So far as paragraph 5 concerned, it is not inherent jurisdiction, it is a conferred jurisdiction by virtue of paragraph 5. And that conferment is only by virtue of notification issued by the Honorable Governor. The Governor has not the power to confer jurisdiction on other courts have also not been taken away by paragraph. Even officer appointed in that behalf can be done, my lord, under paragraph. The Governor need not resort to 1937 rule or any other provision under paragraph 5 itself.
Yes,
He has the power of confer. So the conferment power is not in dispute, my lord. My friend is not questioning the conferment power of the Governor. And by virtue of that conferment power, my lord, the Honorable Governor has conferred the power on district and session judge also and district council court also. To say that if there are two courts functioning in a district, one court will have exclusive jurisdiction, my lord, is not supported by any law, my lord. Either the district court has the power, district and session court has power, or it has no power. Jurisdiction goes to the root of the matter, my lord. Your lordship is aware of this principle of law, my lord. So I need not labor hard on this point, my lord. And lastly, my lord, so Komarchand upholds the power of district and session judge Revoi to try the cases. Komarchand stays the observations or relevant paragraphs which takes away the power of district and district council court from trying the cases if there is a conferment under paragraph 5, my lord. That is one. Second, my lord, that there is a conferment by BNSS or by CRPC, the district and session judge has been conferred with the power. And the argument is that since there is a conferment of power on district council court, the power of district and session judge has been denuded and those notifications have been set to naught because of exercise of power by paragraph 5, my lord. My humble submission, this way the notifications cannot be set aside. If this was so, my lord, if this was so in Philip Carbok Sati, my lord, my friend could have argued that since now there is a conferment of power on district and council court, these notifications have to go. And they have and they are not valid so far as wherever there is a conferment. There is no such submission, my lord. There is no such submission. So therefore, to say that those notifications have been declared ultra vires or declared contrary to paragraph 5, my lord, that argument has not been accepted by your lordship sitting in division bench. That argument has not been accepted. So therefore, now the simple issue as on today to my mind is, my lord, according to me, my lord, is this, that there is a conferment on district and district council courts, and there is a conferment under CRPC on district and session judge, my lord.
Yes.
Under CRPC, my lord. And in neither of the conferment it is said that they will try the cases exclusively, my lord.
Yes.
So then, when there is no issue with regard to inherent lack of jurisdiction in district,
then no case will ever go to the council anymore. Then,
my lord,
because
so
if you don't have product,
no,
everything,
if
all
there are
only the trial part goes to this council courts. And now, what kind of conferment is there?
Yes,
to try offences, that means, but then only
now
to try.
Your lordship is right. Your lordship is right.
Even for matter of now for bail, matter for production,
yes, my lord,
for everything it is before.
Your lordship is right. Yes, your lordship is right. Your lordship is right. Now your lordship will also.
Now whether what kind of powers exercise?
Yes, my lord. Your lordship is right.
Means to try offences.
Yes, my lord.
It should be from a stage of charge sheet.
Yes, your lordship is right. There I have one submission to make, my lord. One submission to make, my lord. The submission is, my lord, that so far as your lordship is aware that so far as the Jantia Hill or Garo Hills are concerned, we do not have such conferment.
Yes.
There is no, there the cases go to the regular district and session judge, my lord. So far as the confusion which has arisen, it has arisen because of those conferment notifications given to the district council courts, failing which there was no conferment, because this is not their inherent power, my lord. Inherent, because had it been a case of inherent power, they could have been exclusive rights. This is a conferred power. So there is, in my humble submission, legal distinction is that it is a conferred power. In paragraph 4, it is the inherent power of district council court. So that is the distinction, my lord, and therefore so far as those issues are concerned, confusion, etc., conformment, etc., my lord, those can be administratively addressed, but that will not give right to the accused who has committed offense, heinous offense of rape in 2016, my lord. 11 witnesses have been tried, and in 2019 he is enjoying a stay, my lord, and by the time evidence will be lost, everything will be lost, my lord, and victim will not get justice, my lord, because of this legal quagmire, my lord. My submission is, my lord, that as on today 11 witnesses have already been examined in the case. There was no objection. They continued with the trial of the offence, my lord. Then at the later stage they realized that we can raise the objection. They are well within their right to raise the objection. They have raised the objection. My submission is that now there is no difficulty, my lord. Earlier also, your lordship, in Commercial has held and the power of district and session judge revoked to try the cases. Earlier also, that part has not been stayed by the Honorable Supreme Court. So therefore, Commercial to that extent will apply. Melvin to the extent will apply that Melvin was, your lordship has taken note, sitting in division bench, that Melvin is passed without taking into note of the fact that there is a CRPC notification in existence.
No, Melvin's Olympia that had not come that time.
In that, Melvin, your lordship is right. Your lordship is right there. So therefore, this is my short submission. I have nothing more to add, my lord.
Yes.
Only thing is that trial is stayed, my lord, and the evidences will be lost. Either it is to be transferred or to not to be transferred, my lord. Trial has to proceed expeditiously, my lord. That is my humble submission.
My lord, a short rejoinder by the submission of the AG. The only session court has a jurisdiction. That is what I gather from his submission. Only the district session judge has a jurisdiction, whereas his not confirming is still there, my lord. So in reality, on records,
I did not say that. Only what I have not used.
But let the AG clarify then which court is the jurisdiction to exercise the trial for this matter. Right? His notification, 2 notifications are there. So concurrent courts are there. No one disputes. It is not inherent jurisdiction.
What will happen now?
Exactly. That is
no cases will go to the council court anymore.
Therefore, in that case, governor confirmation is redundant.
But that's a different chapter.
Another issue, man. Another issue. But there would be a confusion, my lord. If the governor spell out and clarify it that I used to confer earlier, now I hereby withdraw it, I can give confirmation to the district session judge. No one will go wrong. No confusion will be there.
That is what I was personally thinking. Why go to the issue? Even the Giant Hill, you not conferred. Everything is smooth in Garhul's. Why are you conferring here and creating this problem for yourself?
Right.
And even when this issue is written, again conferring powers again to the council court.
Exactly. It is a state which is creating the confusion. Litigants are suffering.
The High Court only. That is the problem. That is the problem because they
are submitting the state's pure suffering.
Most of the time when it comes to me, and by the time the notification, because if we have created 11 district courts, we have got a recruitment system where we have got
the other practical aspect removed from the laws. That in this council court now we've seen that it takes some. Now in the in the national portal we have we shed very poor light because we have cases pending from 1989, which is a stage of and then that comes up because this council and the CIS system also, and so orders are uploaded and so that shows that so we have this case which is above 30 years, 25 years. It looks and so does the thing, and district session judges they have better resources and and the thing is that it's not that they are foreigners. They're all mostly 90%, and even the ones who are there, they are very conversant in local language also. So there's no impediment or hindrance.
Right.
And so I said this council court so burdened with civil matters, which are stuck there only, which don't come to any other court. In the interest of public interest also, that is matters. So that's the only thing.
Of course. Lordship has correctly pointed out.
Strategy.
Keeping in mind all those reality, governor could have revisited his power and clarify the year. So the confusion will not be there.
It speaks very poorly of the kind of legal, the policy
policy. Yes,
ma'am. You take one notification and that's everything.
That would have.
Litigants are suffering. Accused trials are.
Accused suffering.
They are suffering.
The victims are suffering.
It is the creation of the state.
There's some cases that the witnesses have, after 25 years, have been called
for to
speak about an incident.
How will they remember? We don't remember. We don't remember last week.
With greatest respect, if this council wants to enjoy this session, they have to pull up their socks and proceed.
But if this jurisdiction, if they want to enjoy,
yes,
they have to perform.
They have to perform. Yes. That is there. That respect is there.
But your lordship has the power under 227 of superintendence on the district council code also.
That's another thing which is.
Your lordships, because they are all tribunals under the all tribunals courts are under the High Court, my lord. All because the constitutional power of the High Courts are 227 is wide enough power.
Right. That's only
the time has come where your lordship should also, because district and session judges are directly under control of your lordship. Give me constitution. Wow. Such a nice constitution. This power of superintendence, my lord.
Yes, that is.
That is there, but superintendent jurisdiction is there, but that cannot take over the role of the governor, the power of High Court.
We cannot assume a constitution. I mean,
yes,
that we cannot over. Nothing can.
No, your lordship's power is wide enough. High Court shall have superintendence over all courts. So they are also courts. All courts will include district council courts also.
So by exercise 227 that they will not try anymore.
No. Your lordships will, if there is a delay in trial of those cases, and the system is not, so then your lordship can exercise those powers.
Your government advocates or your prosecutors, they will never flag that issue, or any appeal come from the state.
Yes, that those appeals it is not coming to my notice also. Yes, it is not coming to my notice also. Yesterday only I saw one matter which was referred by the police department for seeking opinion on the appeal or not file. Half the time is going into, and it is never placed by, because I requested the law department to constitute a cell where all orders and conviction or acquittal should come in, like in Government of India also we have got central agency where all orders come and they and in smooth manner they are referred to the for opinion, so that whether
an appeal is feasible or
not feasible or not. That's we are living in silos. That's a problem. Different silos are there.
Yes, you conclude arguments, but a lot of questions remain. We don't answered by both of you.
Questions I will try to answer, but the question is, in my humble submission, my lord, is very short according to me, my lord. But the conferment, your lordship, what is appointed in that behalf is possibly your lordship troubling your lordship. That what is the meaning or how it can be constituted? We'll file written submission. We'll do some research on that point also, and we'll file. Your lordship
post it again after 1 week.
Yeah, lordship will file written submission.
Let me do some research.
Yes, my lord. Yes.
Very inconclusive. Just after 1 week for the argument.
Yes.
Other councils will make submissions.
Yes.
Mr. Mansoori.
I was of the impression that I have filed exclusively this petition on the ground of Melvin's wrongdoing. My case is exclusively covered because this case arises from the same district.
So
Longstrein. And the facts are very identical. So I was of the impression, my lord, that I will argue only on that point. How could a notification override the decision of Supreme Court? That was the issue. The notification, my lord, is intended to dilute.
No. You have missed it,
my lord.
You see what Melvin says. What paragraph? What does it say?
It's part of the counter affidavit, my lord. If annexed,
see that. What does it say?
I have cited place that judgment, my lord. Page 72, if your lords will see.
No, you see Melvin's judgment. See the paragraph where it says that.
And last paragraph, last but second paragraph, my lord.
That has not been extended.
Yes, my lord.
So
paragraph 10 point.
So you cannot say that it's gone over the Supreme Court judgment.
We have not.
That's
can't
subject to correction, my lord. I was thinking, my lord, that this notification, of course, is intended to dilute that exclusive jurisdiction part.
Yes.
There is no doubt, my lord.
See. See, it's recorded in the early order also.
Yes, it is.
Moreover, by reason of the judgment of the Supreme Court in Sierra Melvin Olympia, In the absence of notification by the state government extending CRPC drivers, the provisions of CRPC are not applicable. Correct? To the areas except chapters 8 and. But now that situation that does not exist anymore. So your reliance on Mel's Olympia will fall through. Or fall flat rather.
Because this has attained finality, my lord. This judgment has attained finality.
But then it has made
the notification is subsequent development, my lord.
See, what do you mean by that, Mr. Mansoori? You're a seasoned counsel.
My lord,
the thing is that, see, the Supreme Court has made the reference that because it's not been notified, in the absence of notification, CRPC will not be applicable.
My lord.
Now that absence is filled.
That notification has come.
Yes.
So by virtue of that notification, that intention is very clear that they want to dilute.
Anyway, just for further, you prepare.
My lord.
Just for further hearing after 1 week, a party is permitted to file written points or notes and submissions.
Obliged, my lord.
It's not so simple as it looks.
I was of the impression, my lord, but anyway, we'll look into that aspect. Obliged.
Second call, item number 1.
Yes.
Lordship, due to some difficulty, Your Lordship, Mr. Paul will not be available today. No, Your Lordship, he had to leave. Lordship may have it next week.
But Your Lordship, there's no merit for consideration of this application.
Okay,
they have come to the agitate before Your Lordship.
He's not prepared. I think that's why he left. So the reports have records have been received this after 1 week for redemption hearings.
That will come as a fixed matter, Your Lordship.
Mr. Lingdo, you among your counsels only you fix up the matter. Otherwise, court's helpless. The amount of adjournments that are taking place, it's yes.
As convenience of the court, Lordship.
Some counsels don't take adjournments. We appreciate that. Some chambers just do not do hearings. That's all.
I'll oblige.
Hearing 29.
They do only unlisted motions and motions. Yes.
Well, this matter relates to new casual laborers. In fact, we have already argued before, my lord. If my lordship allow us to give a ballot points, submits, my lord.
We put another day, Mrs. Sen. I'll just refresh.
In fact,
and we will submit the bullet points writing.
More than 10 times. Anyway, Your Lordship, we will appraise Your Lordship.
Short written submission also we will submit on that day, my lord. Conclude the matter.
After 2 weeks or 1 week?
After 1 week, let it be.
After 1 week, yes.
Okay. 38.
Let this matter come up to a week.
Where's MS? This is regarding the state, regarding the Rinja case. Where's
Rinja
Mr.
case,
Dev? Or they? They're coming? Very good. Yes, Muthu Bode.
It will come up next week, Lordship.
Why?
Lordship, this morning only I have furnished a copy of the petition to MS Rosie because they have misplaced the file as submitted.
Oh, you're very fair. Okay. Yes, as the then G is not present, just after 1 week. Yeah.
48.
Who's MS Khanda?
Lordship, outstation counsel, Your Lordship, this matter is very clear, Your Lordship, because the first wife should be pleaded in this matter, Your Lordship.
Not impeded.
No, Lordship.
Not
She,
impeded.
no, she did not impede.
MSB Prasa has submitted counsel for respondent number
3, Your Lordship.
3 submitted that the first wife, it appears, not been pleaded in the instance of the application, which is necessary for proper adjudication. So, as there's no representation to our petitioner, just after 2 weeks, yes.
Lordship.
Madam.